So, before we start, nothing in the following broadcast is intended by the author to be untrue, nor to cause hatred against any group, or to cause non-trivial harm, either psychological or physiological, to anybody who may view this by whatever means. So what am I rambling on about this time? Well, you might have seen that a number of people have started putting up disclaimers in those terms on social media. So why are they doing that, and will it do any good? Well, I can answer the second question easily. No, it won't. But why are they doing it? Well, this is in response to section 179 of the Online Safety Act, which I have done a full video on, which I'll link to at the end. But to recap briefly, that makes it an offence for somebody to post information that they know to be false, that can either stir up hatred against any particular group, or can cause non-trivial psychological or physiological harm to anybody who is likely to actually see the message. And that includes people for whom the message might be forwarded onto. So even if you do it in like your private little WhatsApp group, if somebody posts that to somebody else or forwards it on, you can still be liable if that was a sort of foreseeable consequence. So why are people doing this disclaimer? Well, the argument is that by putting this up, they say, well, we don't intend to actually cause anybody any harm or to create a stir, therefore we don't commit the offence. But why is that useless? Well, it's mainly because of the legal definition of intent, which, as I've said on numerous occasions, does not correspond to the everyday use of the word intend. Normally when we say intend, we mean we want to do something. But as a matter of law, you can intend to do something if it's actually the last thing on earth you want it to happen. However, as far as the law is concerned, you intend to do something if it is the logical and foreseeable consequence of your voluntary actions. So if you actually post something that has that result, and your average person would have said, well, yeah, you could see how that happened, that's enough for intent. Now, first of all, I just want to show you this rather magnificent old engine shed, and there is a reason for picking on this one. This is Hawk Shaft, which is really hard to film properly, and on the way back I'll try and get some decent B-roll of it. The thing I like about this one is, and there's another person here filming who probably knows a lot more about it than I do, but the chimney, as you can probably spot, is an extension, because they actually improved the boiler in it to make it more efficient, because this was a very, very productive mine. I'll just have a little pop upstairs so you can have a look inside it. But like I said, there is actually a reason that I've come to this one. And I'll reveal at the end, so it's a big secret. I'm going to be doing a bit of rambling today because there's 3 separate subjects I want to speak about, but they all essentially relate to the same thing. So there you go. Nice view inside. A bit like the old ale and cakes mine, or cake and ale, cakes and ale, whatever we want to call it these days. But right, back to the topic at hand. Like I say, it's not going to be a defence to say that you didn't actually intend to have those consequences if those consequences happen. However, you may have a defence if you say, well, I didn't actually know that, the thing is, you've got to publish something you know to be false. So what if you don't know it's false? What if you actually either believe it to be true, or you're a bit reckless, you just don't care, you're just posting something? Well, you have to be careful. I do think, because we have a few offences where the mens rea element, in other words, what were you thinking at the time, what's your mental state, is knowledge. You get a few offences where it's like, knowingly did X, Y or Z. And the test is quite high. You actually have to know it. Or sometimes though they say, well, you should have known it. It should have been obvious. Any rational average person would have known that was false. But it's a bit like the defamation thing. The mere fact you repeat something. So say you say, there's a rumour going around that the person who did this atrocious act is called such and such, and you give them the name. Well, what you've said there is effectively true. There is a rumour going round. However, it's a bit like in defamation, where it can still be defamatory just to say, here's a rumour going round. I'm not saying whether it's true or not, but the whole point is you are repeating that information. And it doesn't get you off the hook just to say, hey, I'm not saying it's true or not. So you'd have to be very careful how you phrase things. And I think we'll get a lot of test cases on this because it's a relatively new offence. So there haven't been a large number of appeal cases on it yet. But I think this will crop up, what is the actual state of mind? Especially as, you have your Article 10 defence. You've got your right to freedom of expression. Also, it is a defence to the Act because it's a defence to say you have a reasonable excuse for actually broadcasting the information. So it could be something like you hear a rumour that a bear's escaped or a lion's escaped from the zoo and it's out eating everybody in your neighbourhood. You publish that. Well, obviously a lot of people might sort of freak out about it and be psychologically damaged or frightened by it. And it turns out it's not true, but you probably had a reasonable excuse for doing it. You just try to warn people there might have been a bear or a lion in the area. And I know some people will say, oh, well, we are just trying to highlight the threat by saying, oh, this person, or this group presents a threat or something like that. I think people are going to be pushing it a little bit though. I don't think those are, this is slightly my opinion, but also how I know how courts interpret words. I just don't think they'd buy that. I mean, obviously I do a lot of defamation, so second guessing how judges are going to interpret words is part of my job. However, that brings me on to another subject, which is, it is a bit nebulous, and Dan's made a few good videos on this about, it's getting very tricky to know exactly where to draw the line and what is legitimate comment and what amounts to an offence. Now, the idea in law is, it used to be, before the ECHR, and I'll give you an example of a case. There's a guy who published a ladies' directory, which was essentially a big booklet that had very tasteful nude photographs of ladies, and it listed what services they were willing to provide, you can guess what sort of services, and their going rates. And he was prosecuted for conspiracy to corrupt public morals. And his defence was, the conspiracy element was that he had agreed with these ladies. So they were the co-conspirators, even though they weren't themselves charged. But they said the conspiracy is, also, slight distraction here. If you want to see down a sort of deep mine shaft, this is what they look like. Ooh. Oh, actually, I can't actually do that because I've got the thing, I've got the gimbal on anti-tilt, so it's just trying to level up. Trust me, I'm looking down a really, really steep shaft there. That's probably like a good few 100 feet deep. That one is actually capped though, which quite a lot aren't actually in these woods, so I'll have to be very careful. So he published his ladies' directory, and his argument was, well, how's this an offence? There's no statute saying this is an offence, and nobody's ever been prosecuted for it before. But they said, no, the joys of a common law country is, this has always been an offence. Judges don't make law, they merely interpret it, and we have decided that this has always been an offence. And he was duly convicted. However, now under the ECHR, there's this idea that before you can be convicted of something, the offence must be, quote, down by law. That's not just a Steven Seagal film, it has a specific meaning, which is, before you can be prosecuted for an offence, you should at least theoretically be able to work out the limits of what you can do and what you can't do. Now, if it's just a statute, if it's a statutory offence, then you just look at the legislation. So, what's the definition of theft? Theft Act 1968, dishonestly appropriate property belonging to another with an intention to permanently deprive. There you go, it's fairly simple. But what if it's a common law offence? Murder's a common law offence. There isn't actually a statute saying murder is illegal. It's just the idea is it should be obvious. We shouldn't need to make a law about it. But over the centuries, the case law has evolved. So the definition of murder now is, there's still that malice aforethought thing in it, in the definition, which really doesn't actually mean anything. But the definition of murder now is, you inflict an injury with the intention of either killing somebody or causing them serious harm, and as a result of your infliction of that injury, that person subsequently dies. It used to be they had to die within a year and a day. because of like medical advances now, and you don't want the CPS running in on sort of like day 365 and flicking off your life support. Now, you can actually, the year and a day rule has gone. Although if it's over 3 years since the injury was inflicted, you need the consent of the DPP to bring the prosecution. But that's the idea, that you should at least know what you can and can't do. I mean, obviously the law is very complicated. I mean, you've seen the state of a law library, and that's why you have specialist lawyers. No lawyer knows all the law. I mean, I certainly don't. I don't even know most of the law that I'm supposed to know about, to be perfectly frank. But at least the idea is you can look up and sort of go, right, I want to do something. Let me go away, get in the law library and see if I'm actually allowed to. Now, also, the idea is that if legislation is ambiguous, then any ambiguity must be resolved in favour of the defendant. So if you say, well, this particular section could be read in two ways, one that means my guy's guilty and one that means it isn't, then you interpret it in the sense that it means he's not guilty. But you have to actually show that the law is ambiguous. And the problem here is, a lot of people say, well, it's not so much that the law's not clear, it's all the factual basis of the law. So say, for instance, you say something like, public order offence, it's an offence to publish something that is, offensive, abusive, anything like that. Well, it doesn't set out and give you any examples of what's offensive or abusive. So how are you supposed to know? Well, then what the law would do is, they'd say, well, the statute itself isn't ambiguous. It merely says, it's very clear, you can't publish something that is offensive or abusive. And they'll say offensive and abusive are just normally English words. So interpreting those is just a matter of fact. It's not a matter of law. And they say you get into all complications when it comes to interpreting words, but in that particular case they say it's merely a matter of fact as to whether something's offensive or not. So we leave that to the decision maker on the facts. So that could be the magistrates if you were being charged in the magistrates court, or it'd be the jury if you were being charged in the Crown Court. We also have this rather weird thing that whether words are capable, it's like in defamation. It used to be when we had juries, the judge would decide whether the words were capable of being defamatory. But as to whether or not they actually were defamatory, actually I will go this way, that would be left up to the jury. I mean, now that the judge is also the finder of fact in defamation, those two roles have actually been merged a little bit. But you can see a similar thing here. So I suppose you could also argue in front of a judge and say, look, these words as a matter of law could never amount to offensive or insulting or abusive. So therefore, you don't even leave it to the finder of fact, you just strike out the prosecution now. But, like I say, there is a sort of tendency now just to leave these things to juries. I know a lot of people have pleaded guilty to a lot of these offences, and to be perfectly frank, if you say something like, definite incitement, for instance, go around and do X, then yeah, it's fairly obvious you've crossed the line. I mean, arguably, back before all the public order stuff, they might have taken a slightly different view in sentencing. There was that Robin Hood Airport case where a bloke, as a joke, said, he was delayed on something, and he said, we should blow up the airport. And he was actually prosecuted and convicted. Now, after many an appeal, they said, okay, the test is, realistically, was there a serious threat of imminent harm? And no, there wasn't. Although the courts were very unsympathetic to this guy. They actually said, look, you brought this on yourself, it's your own fault, so yes, we're letting you off, but, all the inconvenience and hassle and everything, tough, that's all down to you. So, we'll probably see something similar here. I mean, like I say, the reason I'm sort of rambling is, A, I'm just really, really ill. I've got the lurgy at the moment, so I'm making even less sense than normal. But also, it is rather confusing as to, what the particular law will be and how to, so I suspect, some people will go not guilty on these and no doubt argue along the lines of, I didn't know it was false, what I did didn't amount to intention because it wasn't that foreseeable that the consequences would happen, or that I had a reasonable excuse for doing it, and they'll run all their Article 10 rights. Try and get you a good view here, and there's a reason that I chose this particular walk, because the previous video, where I actually discussed this in great length, you will recall I did it at a couple of engine sheds, and in those engine sheds I pointed back to the wheelhouse and said, that's Hawke's shaft, and that's the one I've just at. But I've walked here to show you from the other thing, and to link the two videos, I've just walked down to the other engine sheds, although there's like 40 foot of foliage between me and those sheds, so now I can't actually show you them. So I'll keep talking. I'll try and think of something else to talk about. Well, right, okay, you can just see it over the top of the hedge. You can just see them both. Hang on, spin round. Okay, so you can see at least one of those engine sheds. There is actually a way around here, but as you remember on the last occasion, it needed a bit of somebody to come around politely with a machete so I could get through to them. But something else I want to talk about is a journalist is now having a row with the police because he filmed, some of the disorder, to put it neutrally, and the police are saying, we want access to all your films and photographs because, that will help us identify the people involved in it. And he said, no, I'm not handing it over. I object just on lots of reasons, but also I have a legal defence because journalistic material, generally speaking, is protected. The police cannot force journalists to reveal their sources or to hand over material. Now, there are some exceptions to that. First of all, it has to be actually journalistic material. So if you just go along and take part in a riot and you're just filming it all, then even if you're going to put it on Facebook afterwards, arguably you're not a journalist. Although the distinction between, of course, real journalists and citizen journalists is getting a lot more blurred now. The courts are quite sympathetic. There's a little view of the engine shed. Go on, spin around. There you go. I'll keep going, see if I can get it. But yeah, the test is the courts do tend to give quite a lot of leeway to journalists. There's a case where somebody's been prosecuted under the Official Secrets Act, and they said, this isn't journalistic material, this is stuff that's top secret information that's been stolen and handed on to you. But the court said, yeah, but that doesn't give you a blanket right to do it, to have it. So in the end, what they said was, we'll appoint independent counsel, they can go through, the police can say what they say is sort of, the evidence thereafter. This guy can look at it without passing it on to the police. He can produce a schedule of stuff that he says, well, yes, this might amount to disclosable material, but then he can provide that list to the journalist, and the journalist can argue as to why he says it isn't disclosable material. So I think in this particular case, this guy might well have a defence to the application. So the police will have to go to court and say, please order him to hand over all this material. If the court says, well, we say this is journalistic material, and like I say, that's not just something you can self-define. You can't just claim it's journalistic material, especially if you are, quotes, caught up in the offending. But the police would also have to show they have a good reason for asking for it. Now, one of the reasons they can ask for it is, the prevention and detection of serious crime. So that'll be the argument they make there. Right, almost there to try and get you this engine shed. And there's one other thing I want to talk about. And the reason I want to talk about this one is, somebody actually asked me in the comments, actually on Twitter, they had a particular circumstance. Now, as it happened, I had done a video on it before, but I couldn't actually find it. Dan found it, but I thought I'd give you an excuse to redo it anyway. Right, here we are, back at those engine sheds. Whew. Right, so there's one of them, and there's the other one. Actually, that's quite a nice shot. Okay, so what did this lass want to know? Well, she was involved in a court case, and she was duly acquitted, but, actually I'll do it this side so you can see, I'll move over, and now you can see the engine sheds again. And what she's saying is, well, look, the press just reported that I was in trouble for this, and, all the prosecution opening was put in the paper, but then the actual I didn't get to present a defence because the judge kicked it and said there's no case to answer, but that wasn't reported. So obviously if you just go and look online, Google the newspaper archives, all you see is that this lass was up for something, but you never found out what actually happened. So, can she report on that? Well, yes, because it's a defence of both contempt of court and defamation proceedings that you're giving fair and accurate report of legal proceedings. It also covers things like inquiries, committees, things like that. So any sort of official proceeding, you can report on it. But it has to be fair and accurate. There's also, it also says contemporaneous. Now there's a reason for that, which is if you're reporting on an ongoing trial, let's say for instance, it's very common, somebody's prosecuted, the people are reporting the trial in real time, so they'll say what the prosecution opening is. This person is guilty of this, and they might report on the prosecution case. Obviously that's all very one-sided at first, but we haven't, until the end of the trial, you don't know what everything is happening. So that's just to cover people being allowed to actually report in real time. But once the trial is over, you can't sort of cherry pick the evidence. You have to make it clear what the outcome is. So if, for instance, you wanted to write about a trial, but you only published the prosecution evidence, you could have done that in real time, because at that time only the prosecution evidence was available. But if you did it after the fact and didn't report, by the way, she was acquitted, then that would be defamatory. But what you can do is you can correct a false impression, because it's misleading because only one side of your trial was reported. Yes, you can generally sort of publish everything else that happened in the trial to sort of give a true account of it. Now what you can't do, you only report what actually happens in the trial. So all these little off-the-cuff briefings from the police and the CPS, where they sort of say to the press, well, this is why we're doing it and we say these people are terrible. And this is why I think actually the Home Office putting out that thing saying 1,000 people have been arrested for public order, these criminals will be dealt with. Well, I don't think it crosses the line into contempt. I think it's getting pretty close, because the implication is everybody who's been arrested is in fact guilty. If you said that about an individual, you'd be in a lot of trouble. But they will probably get away with it because they haven't really identified any specific person. But yeah, that's the general rule, like I say. And it becomes more important now. In the old days of like the paper press, where, as we used to say, today's headlines are tomorrow's fish and chip papers, there's not a lot you could do about it. They would report something, people would read it, they may or may not remember it, but then there's an obligation on the press to go back and report the rest of the trial. So all people heard about was somebody who'd been prosecuted for an offence. But now it's all online. What do they do? Well, this cropped up in that Depp and Heard thing. God, that trial, I thought we'd managed to get away from that. Rolling Stone were able to keep up the original article saying, all the bad things about Mr. Depp. But they added at the end, since we published this article, a jury has found that this was all defamatory. And that's probably enough, because that's fair and accurate reporting, isn't it? Yes, this is the original article. However, it has now been found to be false. And your hypothetical, fair, average, reasonable person would go, okay, fair enough. If a jury's found that, then that's good enough for me. I mean, obviously people will have their own opinions on the outcomes of any legal proceedings. But, oh God, I'm really lost now. That one, never mind. I've got a compass, so I can always find my way back, I suppose. But yeah, so that's what caught out in that Banks and Cadwallader case. That's the one where the last published a story about somebody supposed having Kremlin involvement and being under investigation by the authorities. And at the time she published that, the court said, yep, well, we don't know whether it's true or not, but your publication is in the public interest, and that provides a defence to the defamation claim. However, he was then subsequently cleared by the authorities. But she didn't update the article. Now, this is one of these things. So often, people end up losing millions of pounds that could have been avoided with just slightly more careful use of words. Just one amendment, one correction, one slight qualifier. If she'd have put, since publishing this article, the investigation has been discontinued, then that'd been fine, because that would have been true. But all the other stuff she'd put up, you know, that was, she'd still have the public interest defence, because, you know, it wasn't just about that. But it's the fact that she left an article up there that had a definite false statement in it. Now the court said, yeah, okay, that's only partly false, so, you know, everything else is okay. And that's why she said, oh, well, I suffered, I basically, I succeeded on the bulk of it. But yeah, but it doesn't really matter though, because it's a bit like saying, I'm charged with like 5 counts of burglary, and they only convicted me on 1. You know, you still sort of lost, didn't you? But that little ramble there was specifically for somebody who asked me about something on Twitter. But there you go. Whew, God, my chest hurts. As always, hope you found that vaguely useful, vaguely informative, vaguely accurate. Like I say, I apologise for the slightly less, actually I'm not sure it is like less coherent than normal, because it's not like I'm a model of accuracy and efficiency and good scripting anyway, am I? But I also hope you like this walk, because like I say, where am I today? Well, I just did the walk. This is Unity Woods, which used to be just like mine works, hence all the mine shafts everywhere. But because in the video that I'll link to, where I go into a lot more detail about section 179, and I think you will find it interesting, not least because the BBC has specifically mentioned in the legislation that they cannot commit an offence under the Act. So they are theoretically allowed to knowingly publish false information with the intention of causing people harm. I'm sure you'll all have lots to say about that. I am now considerably lost. Let's just go up here. But if you did, like I say, please consider subscribing to Dan's channel, because he's well on the way to 1 million views. And like I say, much as I love it when people subscribe to this channel, you're under no obligation to, because, you know, I'm just grateful you actually watch the blooming things.